Hello, everybody. We're here for another Asset Protection Wealth Preservation Series interview. Today's interview, I'm really excited to have Bernie Rethore. He's one of the preeminent estate planning attorneys in the city, maybe the state of Arizona, as it were. I'll give you lots of superlatives on this. You can kind of give your own backdrop here in just a second, Bernie. But I've had the privilege of working with him, collaborating with him for about, I think, over 15 years now. And I just really have always appreciated his insights and his willingness to keep us, the advisor, educated, our clients educated, and try to keep them in line. We know that that's not always the easiest thing to do in the world as well. But so he's agreed to spend some time with us here today on this series and kind of have a little conversation. So again, Bernie, thanks for being with us today. Before we get started, maybe just kind of a little background on you, kind of how you got into this this business and kind of why your passions lie, or how your passions lie for this.
So let's guess I'm coming up on 32 years of being in this business. So it's kind of amazing to me that it's been that long. I came out from Connecticut back in 1989 after passing the bar and came to work out here in Arizona and kind of found my way into the estate planning world. I was the guy in law school that loved the tax class. All my buddies hated it, but for whatever reason, tax, was for me. So that's how I got into the estate planning arena. And frankly, it's proactive law. It's not reactive law. We're trying to get in front of problems instead of reacting to try and solve problems. So that's how I got into this business.
That's great. And the love of tax, and I know that personally because that's a big component of this whole estate planning game, if you will. And then, of course, for those that have listened to my Whiskey and Wealths in the past, they know that I'm all about proactive planning, jumping out in front of all these types of things. So I think that's probably why we're in alignment on this stuff. So I guess let's just start with something super basic. What is estate planning? Like, what is estate planning? Why would we do it?
So, everyone has this preconceived notion that you've got to have the big giant house on the hill and tons of wealth to do estate planning. But estate planning is much simpler than that. We're right in the middle of a pandemic. The biggest issue that I'm seeing people that are doing estate planning is as simple as, how do we take care of our kids? If something happens to us, and I have a lot of clients that are doctors that are on the front line of this thing, fighting the good fight. They got small kids at home and they want to make sure that if something happens to them, that at least the guardianship end of things is taken care of. So it doesn't even matter about the dollars. It really matters about how do we take care of the kids. So that's kind of, estate planning is much more broader than what most people think. Let's try and boil it down to its most simplistic. How's that? So there are three ways that people estate plan in the United States. The first one is what we call the do nothing approach. And that is 40% of Americans. And basically, if you don't do estate planning, the state that you happen to reside in has a plan for you. Most states follow the bloodline. And it basically goes looking through till they find somebody. So is there a spouse? If there's no spouse, are there kids? If there's no kids, are there parents? That kind of thing. It's one way of planning. You get no choice on who gets what. The state does the planning for you. You get no choice in who is in charge of making sure things actually happen. The state has the plan for you. The second way people plan is will-based planning, and that is definitely a step up from the do-nothing approach. Will-based planning is focused on making sure that you now get to pick who gets what. You get to pick, who's going to be administering the estate on your demise, and it goes one step further. It also handles incapacity or disability. So if you become incapacitated, I always use the dementia person as kind of an example. If you have dementia or something along those lines, you probably shouldn't be handling the finances anymore. So there's planning documents in that will-based plan that solve that problem as well, so that you don't have to go to a court and have a judge now decide who takes care of you, where you live, and how is your money spent for your benefit. You don't want to do this. They do it all the time down here in the local courthouse, 9 a.m. If you ever want to watch one of these, you can. And it's literally people putting themselves on trial for competency. It is not a pleasant experience. So the will-based plan is definitely a step up. The third way people plan is trust-based planning. And that's basically the same idea as will-based plan, except the difference is we don't go through probate when somebody passes away. So with a will-based plan, you are going to go through probate. With a trust-based plan, you're kind of getting out in front of those ideas ahead of time. Because what you're doing is you're not only saying, this is how I want my plan to work, but you actually take steps while you're alive to actually put it into place and implement it. And your office is really great about helping us fund those trust-based plans so that the assets ultimately line up with the instructions. So trust-based plan in my mind is even a little bit better than the will-based plan because we're actually getting out in front of it even more in terms of getting ready if something bad happens, whether it's disability or death. So that's kind of the big 36,000 foot view.
Excellent. And so if I'm hearing what you're saying, look, estate planning really applies to virtually anybody who wants to have control of the disposition of assets, the caring for the family, and ultimately how they want things to go in incapacitation circumstances, regardless of house on the hill or house on the bottom of the hill. Is that a fair?
Yeah, absolutely. Even like, a lot of my younger clients, they're paying off student loans. Okay. They're not in that accumulation phase because they're so burdened with debt. They're just kind of making things, making ends meet. So at a minimum, you don't want your kids going into child protective services because you didn't do a guardianship for them. And now somebody's got to go down to a court and get a judge to, to basically say where the kids go. So even if they do nothing else but that, guardianship and a basic healthcare power of attorney are probably the first starting points of anything. The money part arguably will take care of itself, but not some of those family issues.
Yeah, and that's one of the reasons, Bernie, that we put together this series is, as those of you who've heard me talk before, there's asset protection and we think asset protection attorney, but I know you and I believe that asset protection and wealth preservation, it's everything. I mean, it's this global approach to how do I protect my wealth? How do I protect my family? And of course we'll get to this in a little bit, but how does my planning, how is that going to offset or mitigate some of the tax? Yours and my clients are often tax, particularly avoidance. And so I think that's why this is such a critical thing. Now, you mentioned will, you mentioned trust, you mentioned probate. Just for sake of those that perhaps are entirely unfamiliar with what those terms are, and I realize anybody can go Google those terms, right? That's the easy thing. But if we were just to look at some of the basics of what is a will, what is a trust, how could a trust be utilized? And again, 36,000 feet. We don't have time to go through, all those textbooks behind you to determine how this stuff all fits. But kind of just walk us through some of the basics of maybe phase one of an estate plan and then perhaps phase two of an estate plan.
So let's just talk basic documents. So powers of attorney are going to handle financial and medical decisions if you can't do it yourself. So those are geared specifically for incapacity. All right. And typically you're going to see two types. You're going to see what they call a springing power of attorney, meaning it springs into life on an event, usually disability. Some of my older clients will sign powers of attorney that are effective immediately. Because they want to get their kids involved with helping to manage some of the assets early. So those are the two types of powers of attorney that are out there. A will is a dispositive document, who gets what. Trust is a dispositive document, who gets what. But the trust goes a step further because it's also a financial management tool. So it really kind of goes part of your arsenal of things that you need to try and manage all the various wealth pieces of the wealth. Because you think of the trust as a funnel. Everything funnels into the trust, so that if they decide they're going to make a change, they don't have to go to each beneficiary on an account. You just change the trust, everything's going to funnel in. With the trust as well, you're going to get some asset and divorce protections in there for the family. We talk about this all the time. Every doctor that walks through my office, the first thing they want to talk about is asset protection. And dirty little secret of asset protection is there's not a silver bullet. If there was, I would have retired years ago, because everybody would have wanted exactly that particular thing. But asset protection is kind of layers, and the estate planning is kind of one of the pieces of those layers. Inside the estate plan, and I'm going to go off on a tangent here, but I think it's relevant to what you're talking about. We can asset protect our heirs or our kids or our beneficiaries in a way that we can't do it ourselves, all in the way that we set up the estate planning. So do I give the asset outright to my child? Good luck, do what you want, but if they get divorced, half the assets I left to them went out the door with the outlaw? Or do I want to leave it in such a way to them where they can use and enjoy the benefits of that bequest, but if something bad happens, like a divorce or a business fails and now there's a bankruptcy, the bad guys can't get at the assets. You probably remember my Ted Kennedy story. I'm starting to date myself a little bit now with Ted Kennedy because my younger clients look at me a little bit blank. They don't remember him, except for that there was a TNT show not that long ago, which was, Chappaquiddick, and now all of a sudden they know.
It's now pop culture. It's now current.
Right. So now they know who Ted Kennedy is. But Ted had a bad day driving many years ago. Okay. The passenger did not survive the car accident. Ted never gets sued for wrongful death. So the question is why? Well, it's not because he was a Kennedy. All right. It was because Ted didn't have any money. And if you really boil it down, you go, well, wait a minute, he was a Kennedy. Clearly there was money. I've seen the house in Hyannisport. Well, what it boiled down to was Dad left money to the Kennedy boys in such a fashion that if something bad like that happened, the Kennedy fortune was protected. So in the law, there's a difference between legal ownership and control. Control was with Ted. He could decide how to take money in and out of that trust, okay? But ownership was with Dad, even though he was deceased, okay? So it wasn't Ted's money, in essence, to give away when the accident happened. Same thing is true. Ted had many wives, okay? Each time Ted gets divorced, half the Kennedy fortune didn't go out the door with the outlaw, simply because it wasn't his money to give away. And so those are types of planning that you can build into your, whether it's a will or a trust, for the benefit of your family, that you can't give to yourself with asset protection. And I always say, if your parents are going to leave you money, how do you want to get your money left to you? Do you want it left to you like Joe Kennedy did for Ted? Or do you want to just have them give it to you outright where it's now gettable in those types of situations? So, of course, the answer is always, you're better off getting it in an asset protected way.
Yeah, and I love that story. And that is the story you shared with my wife and me when I suggested, now, if I end up dead, I want to make sure that some schmuck can't come in here and reap the benefits of my death by courting my wife. Well, now, widowed wife. So right. That's this. I do recall that story. So I think that's a great spot. So obviously that was a useful estate planning technique that the Kennedys used that we could all learn from. Let's talk about the opposite side. Let's switch gears and talk about the common mistakes that folks make. And you mentioned something a second ago. I've run into them, and I don't want to steal your thunder if this is the most common, but where they're like, okay, we have $10 million that we plan to bequeath to our 5 daughters or 5 siblings, right? Or 5 kids rather, right? And we want $2 million each to go to those kids. And we're going to have real estate, and we're going to have business interests, and we're going to have investment accounts and all these types of things. And literally the document more or less says, yeah, a fifth, and that's it. So my guess is that's not terrific planning, but you're the expert. So talk to me about some of the mistakes that you've seen through the 32 years you've been practicing.
So yeah, that's definitely a challenge that we see come up all the time. Some siblings shouldn't be in business with other siblings. And that's in essence what happens even with a piece of real estate. The family compound, that's the vacation home. How do you manage that home? Basically, those kids are in business together. So there may be some additional thought that needs to go into how to actually manage that property so everyone enjoys the benefit of it, but yet you don't have World War III along the way. So that's definitely an issue that we see come up. A couple of other things. Banks are famous for rewriting people's estate planning. Okay, they don't understand. I mean, you go into the bank, they're basically cutting their teeth as the teller. Okay, and yet they're going to be very quick to tell you how to title your assets and how to put down beneficiary designations on those counts. Okay. So we see the banks rewriting the plan, having no idea what the planning actually is supposed to do. So, a client comes into the bank and says, I want my son to be able to help pay my bills because I'm getting older. What does the banker do? Well, he's on a commission structure to open new accounts. He opens a new account. Now it's not in just mom's name. It's now in mom and son's name as joint account holders. Well, one, they cause a taxable event doing that because it's a gift tax issue if it's more than $15,000. And they've also now made that asset gettable if son has a bad day driving. Now mom's asset that she just put him on is now gettable in that situation, okay? And then maybe there's 3 other siblings who now just got cut out of that account because the bank made it joint ownership because that account would never flow through either the will or the trust. So you got to be very careful about it. That's why we ultimately want all the assets to funnel into the trust so that the bank can't rewrite the estate planning. The other issue with the bank is the fact that they continue, they have no idea what they're doing along those lines, and it's all about opening up the account. So it's not good on their part. Second thing that we see is the assets don't line up, which is kind of a parallel to what we're just talking about. So the assets are going one direction because the bank said put a beneficiary designation on it, and the trust says it should be going, or will says it should be going another direction. So that needs to be annually reviewed. You guys do a great job of kind of sitting down with your folks every year and kind of going through where are the assets, what have you acquired, what have you gotten rid of, and making sure that you guys have a handle on all the different pieces and parts so that everything's flowing together. The third biggest issue that we see is the planning never gets looked at after the first time they do it. So people do the estate plan, they check the box, I did my trust, I did my will, and then they forget about it and they throw it in the drawer. My experience is 90% of those plans fail, not because the planning was done wrong on the front end, it's because circumstances changed that frustrated the ultimate goals. And so we at least like to see the planning reviewed at a minimum every 3 years, but we think an annual review, kind of like what you all do, is really the better way to go at it. You know, what's changed in the law, okay? What's changed in the family, whether it's personal or finances. And then frankly, my opinion about what you should be doing is going to change along the way as well, because circumstances change. Let's give you an example of this, retirement plans, okay? So way back when, 2005, retirement plan was the worst asset in the estate, okay? And it's because it was instant taxation once it got past the spouse, excuse me, to this next generation. The estate planning or the retirement plan then, because the tax law changed, all of a sudden became the best asset in the estate, because now you could pass that retirement plan on a tax deferred basis to the next generation, subject to mandatory distribution rules, as you know, but based on a much different life expectancy. The age of the child versus the age of the person, the participant. Well, that changed again. All right. So now, as of this year, they've thrown that out the window, and now they've gone back to basically a 10-year time period. So it's not quite as bad as where we were in 2005, but still not great, because they're going to basically force the retirement plan to be fully distributed within a 10-year time period, subject to some exceptions to the rule. So one of the takeaways for your folks is, if you haven't looked at your retirement plan designations since the beginning of January, it's time to do that, because it probably is going to look different than where it was this time last year, simply because the law changed. That impacts the planning. So that's just a food for thought on that one.
Yeah, no, the titling and the beneficiary, I remember years ago, I ran into a client situation, and we were reviewing their trust document, their estate plan, and then we were reviewing their life insurance, and we were reviewing their retirement plan. And we just kind of, and this is before we really had a good sense of all the collaboration that we've had with you, but even then it was still, I'm like, hey, do you realize that your beneficiary was 3 different things across the 3 of those asset, I'll just call them assets or items, right? The trust, the life insurance, and the retirement plan. And I just asked them that, no, I had no idea. And that goes to the reviewing. And that just kind of made me think of, you tell me if this is the case, but I'm pretty sure I remember this as well. Somebody now thrice divorced, had a life insurance policy that they had picked up years and years and years ago on wife one, or with wife one rather, and now is doing the estate planning, and this is it. This is the final wife, presumably, and lo and behold, dies, and the life insurance was never changed. The beneficiary was never changed from spouse one in this situation. And I just remember thinking at the time, like, well, that can't possibly be. We have the legal document here, and that was my first experience with the fact that actually, in fact, the life insurance beneficiary information supersedes in those cases, or at a minimum can create some conflict. So I imagine you've had some of those scenarios as well that you've hopefully been able to proactively deal with.
Yeah, it's funny you say that, because I had this case not that long ago where this little 92-year-old woman comes in, and she says, we go through the whole what happens when somebody passes away, and she says at the very end, "Hey, Bernie, I just got a quick question for you." She had a 1950 Jag, or he had a 1950 Jag, and he had totally restored it. It was in primo condition. It was a nice vehicle. And she goes, so she pulls out the will, which, oh, by the way, was written in pencil. All right. And the will says the car goes to the nephew. All right. Then she pulls out another piece of paper that basically says the car goes to the brother-in-law. Okay. Then she hands me the title, and it's titled to her and him. So her question was, who gets the car? Well, of course, she does.
She does.
The title ultimately doesn't matter what the will said, didn't matter what the trust said, because it never got past the title. It went somewhere differently. So for me, it wasn't so much a who gets the vehicle as to what was he really trying to do. I don't know.
Right. Yeah.
She couldn't tell me.
No. Well, at least she had a nice car that she couldn't drive probably at 92. I don't know how spry this young lady was, but
she sold it.
She sold it very well. So I think a lot of our listeners would be upset if I didn't introduce taxes to this discussion. And so I want to give everybody just a quick disclaimer that oftentimes when we talk about taxes with respect to estate planning, there's a lot, probably way more rabbit holes that we could go down to, because if you do this, but then this, but if you do this, but then that, and if you do this, but no, there are exceptions here. So broad strokes for me. And this kind of goes back to the first point, which is, if it doesn't save me taxes, I've heard that the tax liability on estate plans now are, this exorbitant number that less than 0.5% of people will ever experience. So I really don't, there's no taxable implication associated with this. Could you just talk on taxes in the context of estate planning for us, Bernie?
Yeah, and so I'm going to circle us back to another thing, which is mistakes that I see, and this kind of ties into that. So let's talk taxes on a broad base. So right now, this year, okay, each person has an $11.58 million exemption, okay, which basically means you got to get over a penny over that before you start paying tax. Tax rate's 40 cents on the dollar, but between a husband and wife, you're over $23 million if they do some basic estate planning. You can double up that exemption amount. That exemption is indexed for inflation. Okay, meaning it's in theory going up every January 1. That's going to continue until 2026 when the law expires, and then we go back to where we were 3 years ago, which I can't give you the number there because it's still going to be indexed for inflation, but it's basically going to be a $5 million start, indexed for inflation. Your guess is probably as good as mine, but we're not going to know what that number is till we get there.
Right.
So most people are not going to have an estate tax problem. When I first started practicing law, it was $500,000 as the exemption, okay? Life insurance in a house, and you pretty much went through the exemption pretty darn quick, okay? Mm-hmm. But today's world, I just don't see where most people have that type of, have that tax liability sitting out there. So taxes probably isn't the tail wagging the dog anymore. Really it gets back to where we started, which was the family and taking care of the people you care about with the estate planning. With that said, I still do tax planning for clients because I don't know what the Congress is going to do. That amount is set by Congress. We are in election year. Things could look very different in November. Come January 1, they want to scrap the estate tax exemption and go to a zero. And so every dollar on the first dollar is taxed. I don't know. So I always do the planning because I just don't know how to anticipate what the Congress is going to do. All right. Plus, there is the benefit of some asset protection for the surviving spouse. So basically what happens is when you do a little bit of tax planning in whether it's a will or the trust, you basically say on the death of the first spouse, make a his and her share, okay? So that you lock in that exemption amount. So even if it changes in the future, the surviving spouse is locked in some of the money. The money on the deceased spouse's side of the ledger is asset protected. So if Bob the Beach Bum shows up or Stormy Daniels shows up, they can't get at the money, okay, of the deceased spouse because that's now become an irrevocable bequest. Now, more than likely, the surviving spouse is going to be the beneficiary there, so it's really there to protect him or her from the bad actor, if you will. Same thing is true if that surviving spouse has a bad day driving. It's a school bus full of kids. I don't care how much car insurance you got, you don't got enough. All right. At least that side of the ledger, the deceased spouse's side of the ledger, is always going to be protected. So I think it's worth doing the tax planning because I get not only the benefit of the tax planning, but I get some asset protection and some what I call remarriage protection for that surviving spouse as well. And that's kind of the other mistake that I see people make, which is when that spouse dies or when somebody dies, especially when you have a lot of joint tenancy assets, people don't think there's anything to do because they're going right to the last step. If it's a joint tenancy asset and I'm a owner with you, okay, last one standing wins, okay? Well, that's easy. That's a distribution step. But there's steps in front of that that all need to get done as well. Let me just run through it real quick with you if we've got time.
You bet.
So there's 4 things that happen every time somebody dies, okay? The first step is a valuation step. All right, the reason why we go to the valuation step is for tax purposes. There are 2 taxes in play, estate tax and income tax. Well, we've already talked about the fact that estate tax probably isn't going to be applicable to most of us, okay? Mm-hmm. And if you have a surviving spouse, there's another exemption available called the unlimited marital exemption, which is exactly the way it sounds. You can leave an unlimited amount of money to a spouse without, basically you're kicking the can down to the second spouse passes away. So really what we're focused on when the first spouse dies is the income tax side of things. And this is how this works. You buy Apple stock, you pay $100 for it while you're alive. That's your tax basis. Fair? If you sell it for $500 while you're alive, you've got a gain. If you sell it for $50 while you're alive, you've got a loss. The rules are different when you die. When you die, the government says, we don't care what you paid for the Apple stock. We want to know what it was worth on date of death. So if the Apple stock was worth $500 on the day you died, that now becomes the new tax basis and you wipe out all that gain, okay? That's some significant tax savings for the surviving spouse. Now, my Apple stock is a very simple example, but apply that concept to a house that you've lived in for 35 years, okay? There's probably some appreciation sitting in there. The burden is on the taxpayer, not a surprise there, okay? We have to be able to prove the numbers up to the government. We also live in a community property state, which means we get 100% step up when somebody dies, not just the half of the person that died. So in a lot of the other states, we're only one of 6 states that's community property. You know, those other 44 states that are out there, they're only going to get half the benefit versus what we have here. So one of the things we do as part of the planning is we basically look at doing a community property agreement to get the more favorable tax advantage. All right. Second step is we formally notice creditors. And the reason why we do that is we're trying to cut claims off against the spouse and the estate. So in Arizona, a creditor can come after the estate for up to 6 years. What's your comfort if you're a trustee making a distribution to anybody if you think you got a 6-year exposure?
Right.
Okay. So the law says if we formally notice creditors, we can compress the time period from 6 years to 4 months. Sounds a whole lot better to me. Now, my older clients all say, but I don't know anybody. I paid off my mortgage. I don't have consumer debt. I don't have student loans, that kind of thing. Yeah, I get that. But remember, the person that you've asked to step into your shoes may not know all those things. They're flying blind, okay? They're basically getting thrown into the deep end of the pool to figure out who's on first. But things as simple as Medicare, okay? Medicare can take up to a year to bill. So the sooner I can cut off claims against the world, I want to do it, because it protects the successor trustee or the executor of the will from those types of claims, so that ultimately you can get distributions done. Third step, this won't surprise anybody. The government wants a tax return from you even if you're deceased. Okay. You obviously are not here to sign it. All right. So the surviving spouse typically would sign that return. It's ultimately what retires the Social Security number with the government. So they're not looking for tax returns in future years. And then obviously the last step is the distribution step. That's the good step that everybody wants to rush to. But obviously you can't get to the last step without doing the first three in order to protect the trustee and the estate from future things. So that's kind of the mistake I see. So even when the first spouse dies, they forget to do that step.
Yeah, I mean, that's just such good stuff. And I really feel that our listeners are going to find value in this. And I mean, look, it's get out in front of it, prior proper plan. Everybody knows that language. Make sure that we know the differences between will and trust planning. I'm just going to presume, Bernie, that no one does the first phase, which is the do nothing side of it, because hopefully you can beat them over the head. I can beat them over the head. Look, you got to do this, right? It's pretty important. But moreover, the peace of mind that folks can have when they do this, while keeping an eye on the fact we need to review it when things change. We have another child, we have a new business that we start up, we have new assets that we accumulate and so forth. And really, even though the taxes might have less of an implication currently, we never know how that's going to go. What I'm hearing is, let's make sure that we have instructions, and then let's make sure, to your last point, that we have barriers in place to prevent people or entities or things from taking that which you have built because of a bad day driving, because of a poor titling, or whatever the examples that you've graciously shared today. So before we wrap up, any last thoughts? Any last kind of calls to action that you'd like to throw out there? I know I'm kind of putting you on the spot here, but I just figured we'd end with that today.
Yeah, that's always a good one. So like I say, the biggest one I think your folks should really be looking at is retirement beneficiary designations. And, some of us have individual retirement plans. Some of us have this stuff at our work. They still are the same thing. You got to look at it. So even though the employer might be doing some of those 401k or 403b type things for somebody, you all got to know what that is, so that frankly you can help navigate them through the different things. So looking at those beneficiary designations, I think is probably the biggest call to action. The other thing is, if you haven't looked at your plan in the last 3 years, you should be looking at your plan. Statistically, the Wall Street Journal says it's 18.6 years between the time that people look at their planning. Okay. I have a theory about it. It's very unscientific. I think we think about it the first time when the first child's born. We actually get around to it when the second child is born. And then when that child goes off to college, we go, oh my God, we haven't looked at our estate planning. And so I think that's where that 18.6 years comes from. But it's just way too long to go without looking at the planning. Things change. I'm absolutely convinced of that. And so all of that impacts the estate planning, and ultimately you want it done the way you want it done. So make sure you're putting a set of eyes on it on a regular basis.
I don't know that we could end it any better than that, Bernie. Thanks so much for your time. Folks, get out there, review that plan. If you don't have one, get one started. And let's wrap it from there. Thanks again for the time. Really appreciate it.
Yep. Thanks for having me. Appreciate it.